Hello, everybody. Hello, Sir Philip of Sea Lake. Hi, Ava. Oh, we're down to the end of the bag. That makes Ava happy because that means Ava gets all the crumbs. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Hello, Joey Big Donuts. Hello, Wire Mother. Hello, Auntie M. Hello, Jenny Green. Hello, Linda Applegate, honey. Hello, Mortimer Duke. Hello, Mark Addy. I brought the little space heater in here because it was getting really cold. It's chilly tonight. It's like 32 degrees outside. And Earl doesn't like it. He doesn't like it one bit. He's very vocal. Hold on. I don't know if you'll be able to hear it. I wasn't expecting it to be as loud as it is because of the fan. But hold on one second. Can you guys hear it? Here, Ava, you get a bonus one tonight. You get a bonus treat. Yeah. It's bonus treat and then crumbs. And then that kills that bag. You're so good girl. Softly. Okay. No. Yes. We've got a no, a yes, and a softly. So I'm going to assume it's the softly. Oh, hello, Charlie. Well, he's not doing it now, but Earl was very, very vocal, and I thought it was from the heater. And the second I turned the heater off, he stopped. But now that I turned the heater back on, he's not starting back up. Maybe it's so. About a year and a half ago, Chex and Cherries had sent them a laser toy. The laser died. The jutting puffball still juts, but the laser doesn't spin. And that had him quite upset for a while today. He kept trying to get me to fix it. He kept meowing and walking me to the toy. And then just staring at me like, Okay, human, make it work. It's like, okay, I charged it. That's as much as I could do. Here, I'm going to turn the heater off. Ava, move. That's my spot. That is my spot, you big old spot hog. It's bad enough you take up the entire bed. Now you want to take up under my desk. Not fair. Not fair. Puffballs. Jetting puffballs. That's a difference. A very, very big, big difference. Oh, there he goes. He's going to start back up. It must be the toy. Oh my goodness. Excuse you. It must be the toy. I don't know. That's the only way that the missus gets anything done around there, huh? Hi, Earl. What's up, buds? You're gonna come tell me all your woes? There we are. Hi, buddy. I have pants on. I have pants on for sure. Oh, and I just dropped my... Yep, it's Earl. Earl Grey the cat. He's going to be very interactive tonight. You want some treats, buddy? Here. Have some treats. I've got another laser pointer toy. This one's C-Rex sent. I've got another one charging up for him. Well, when she takes my foot space, it is too loud. She's there right now, taking up my foot space. I thought that was the black hole. Where's C-Rex at? I gotta text her. I don't see her. She must not have gotten the notification. I am a little earlier than normal. Lord knows she wouldn't miss a chance to see Earl. Not on the weekends. That's when the party girl comes out. So for partying tonight, we've got Judge Hart. I sped him up, but not like sped him up. I removed the spaces in between his words, so it seems like he's more sped up. Ava, have some crumbs. Have some kitty crumbs. So yeah, he's not as insufferable. I like Judge Hart. He's funny. He is funny. But he's hard to listen to sometimes. Hello, Shane. Good to see you.
And good afternoon, everyone. This is the time set for First appearances will take up individuals that are, first of all, in custody. And first case is State of Kansas versus Richard Robert Crumrine, 25 CR 289. Stayed by Mr. Regier. Matter comes back before the court this day, and this matter comes back before the court after on 10/21/25 there was a bond forfeiture bench warrant ordered by Judge Satterfield. And Mr. Crumrine, what I would suggest you do is to contact Mr. Watts and see if he would be able to make a motion to schedule all the cases.
Oh, man. The cats helped me edit. Either part of Mr. Crumline's docket is going to be down the road, or it got deleted. I'm sorry. I knew it. I knew it. I knew it. I tried fixing whatever it was that had changed when I got up and went to the bathroom, and I came back and something was different. But when I used the back editor tool, I had already made a couple more edits before I realized something was different, and I couldn't find the change. I'm sorry. You know what? Here's what we'll do. We're going to skip Mr. Crumline, and I will quick fix it, and then we'll run it at the heel of the docket.
Thank you.
Anything further, Mr. Regier?
Your Honor, as a point of clarification, that December 8th setting, is that for control purposes?
It is. Felony
Nothing.
preliminary hearing control docket.
Nothing further from the state, Your Honor.
Court is in recess.
Thank you.
And cases entitled State of Kansas versus Randall Wayne Drown Jr., 25 CR 396. Good afternoon, Mr. Drown. You're charged by way of information, count one, on or about July 14, 2024 in Butler County, Kansas, with possession of methamphetamine, a level 5 drug felony. Count two, same date, location, possession of paraphernalia for use, class B, non-person misdemeanor. Count three, same date, location, driving while license is suspended or canceled, class B, non-person misdemeanor. Those are the charges pending against you. Do you understand the charges?
You said what's the felony?
The felony is possession of methamphetamine, level 5 drug felony. And do you understand the charges?
Why is it a felony?
Because that's what, excuse me?
I was gonna say Wichita catches me all the time with crap, and I've never been charged with a felony through Wichita.
Say I need a drug and alcohol assessment without saying I need a drug and alcohol assessment.
Well, Mr. Drown, the court advises you this is being charged pursuant to State of Kansas statute, and possession of methamphetamine is a level 5 drug felony. I do not know what your experience has been before in other jurisdictions.
Okay.
You do have the right to counsel, cannot afford an attorney. One would be appointed to represent you. Are you currently employed?
Oh, I'm not.
How long has it been since you worked?
It's been a few years.
Do you have any money saved back to hire an attorney?
Been a few years, since when he started using methamphetamine. And does he have any money saved up? No, it went to methamphetamine.
No.
Court appoints Jim Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. Next hearing date is before myself and that would be on Monday, January 5th, 2026 at 2:30. Monday, January 5th, 2026 at 2:30. You do need to be present in person, by Zoom at that time. Present by Zoom at that time, Monday, January 5th, 2026, 2:30. Next item of business is to set appropriate bond. I note there's been a tentative bond scheduled for 2,000 cash or surety. Any objection to that amount and type of bond, Mr. Regier?
No objection, Your Honor. If the court is ordering all standard conditions with special emphasis on no contact with illegal drugs during the pendency of this case. Besides the one felony count currently before the court, this is a defendant with a history of other convictions of a varying nature from the state's information. So 2,000 cash or surety from the state's perspective is quite generous and appropriate under these circumstances from the state's point of view.
And Mr. Drone, the court does order $2,000 cash or surety bond. 2,000 cash or surety bond.
2,000 cash.
Or surety bond.
So that means 200 or what? What's
That's a typical bail bondsman fee.
okay?
Anything further, Mr. Regier?
Nothing further from the state, Your Honor.
And Mr. Drown? There being nothing further, court is in recess. Have a good day.
So I'm pretty much still be unheld, correct?
Yes.
All right.
Next case on first appearance docket, State of Kansas versus Corday Devontae Lewis, 25 CR 506. Good afternoon, Mr. Lewis.
Good afternoon.
You are charged by way of information, count one only, theft, a level 9 non-person felony. This is allegedly of a Ford F-250 truck, allegedly owned by a Jeremy Hinkle. And Mr. Lewis, do you understand the charge pending against you?
Yes, sir.
Mr. Lewis, you do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Mr. Lewis, are you currently employed?
No, sir.
How long has it been since you worked?
I've never had a job. I just got out of jail.
Okay, based on your lack of financial wherewithal, the court does appoint counsel to represent you. Jim Watts is appointed to represent you at all stages of the proceedings. Court schedules this matter next before Judge Crum on December 22nd, 2025 at 2:30. You do need to be present by Zoom process at that time. Next item of business is to set appropriate bond for you. And Mr. Lewis, what is your current address?
The jail.
I'm actually homeless. I don't have nowhere to stay.
All right, thank you. And do you have any family that reside in Butler County, Kansas?
I got people in Wichita.
Okay, do you have any in Butler County? Recommendation for bond, Mr. Regier?
Your Honor, it would appear based off the defendant's statements on the record that he has indicated that he is of no fixed abode and has few, if any, ties to Butler County. To that end, besides the charge currently before the court, which the state does consider to be quite significant, the state understands this is the defendant with a history of a number of prior adjudications and the convictions that the court may consider relevant. Besides one felony battery on law enforcement officer conviction, multiple adjudications, at least 3 for criminal damage to property, misdemeanor theft, felony theft, 2 adjudications for felony burglary, as well as 5 person adjudications, at least one of which appears to be a felony.
Yeah, just leave him in there. He doesn't need to be out in society.
With all that being said, the state is recommending a high bond in the amount of $10,000 cash or surety, subject to all standard conditions, with special emphasis on no contact with the alleged victim. State is further seeking GPS monitoring.
Court orders the bond and conditions as set forth by the state herein. Court adopts the recommendation of the state for bond and conditions thereto. Anything further to come before the court, Mr. Aguirre
No, Your Honor.
and Mr. Lewis?
I don't understand what just happened.
You've been granted a bond, and
Okay.
the amount of the, once again, Mr. Aguirre, the amount of the bond was how much? $10,000?
$10,000 cash or surety, subject to GPS monitoring and no contact with the alleged victim were the state's recommendations, Your Honor.
And you've been ordered to be on a $10,000 bond, GPS monitoring, all conditions as recommended by the state. Anything further, Mr. Lewis?
No, sir.
There being nothing further, court is in recess. Have a good day, Mr. Lewis.
Yeah, me too.
I'm hard of hearing, so
Okay.
hopefully I got my hearing aids turned up, but
State of Kansas versus John David Siggins Jr., 25 CR 176. Good afternoon, Mr. Siggins.
hello.
You're back before the court after posting bond in the amount of $1,500 surety, $1,500 surety bond. Subsequently, the court advises you are charged by way of information in count one on or about July 4, 2022 through August 2022 in Butler County, Kansas, that you committed a theft, a level 9 non-person felony of a 2000 Polaris Sportsman 500 cc 1999 Kawasaki Lakota KEF 300 cc and $1,866, all of the same belonging to James or Colby Chandler. That is the only charge pending against you. And do you understand the charge?
I do.
That cannot be the first time that he has heard that name, or the first time that he's realized who the victim was. Unless, how many of these Kawasaki's has he stolen? I don't know. But when the judge mentioned the name, he literally mouthed OF.
You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Are you currently employed?
I'm not.
How long has it been since you worked?
About 9 months. Been
Do you have
taking
money
care of my
saved
mother.
back? Do you have
Sorry.
money saved back to hire
I
an
do.
attorney?
I do not.
Based on your lack of financial wherewithal, the court does appoint Mr. Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. Court sets your next appearance date. This would be by Zoom for a felony preliminary hearing control docket, Monday, January 5, 2026 at 2:30. Monday, January 5, 2026, 2:30 by Zoom before myself. Your bond's been posted, counsel's been appointed, your next date has been set. Anything further, Mr. Aguirre?
Your Honor, this case appears to involve an appearance bond previously executed out of another jurisdiction. The state would be requesting clarification as to whether or not that bond does include a no contact order with respect to any alleged witnesses or victims in this matter. The endorsed witness list does appear to include multiple individuals identified.
The court advises that the answer is no. There are no individuals or no contact. The court does order you, Mr. Siggins, for you to not have contact with the endorsed witnesses herein. Officer Joel Sibley, Jennifer Lee Siggins, James Leslie Chandler, Colby Jordan Chandler, Margaret Ann Chandler.
Okay.
Anything further, Mr. Regier
No, Your Honor.
and Mr. Siggins?
No, Your Honor.
Court is in recess. You're free to go.
All right.
Have a good
Thank
day.
you.
And the next individual I have is Brandon Skilling. Brandon Skilling.
Yes,
Mr. Skilling, you are charged by way of information in 25 CR 417, count 1, on or about January 10, 2025, in Butler County, Kansas, with possession of methamphetamine, a level 5 drug felony. Count 2, same date and location, possession of paraphernalia for use, a Class B non-person misdemeanor. Count 3, same date and location, driving while license is suspended or canceled, Class B non-person misdemeanor. Those are the charges pending against you. Do you understand the charges?
yes, yes and no.
What do you
I
not
don't,
understand?
I don't understand the first one of having methamphetamine.
The full count is on or about the 10th day of January, 2025 in Butler County, Kansas. Brandon Lee Skilling did unlawfully possess an opiate, opium, or narcotic drug or a stimulant designated in subsection D1, D3, or F1 of KSA 65-4107 and amendments thereto, or a controlled substance analog thereof, specifically methamphetamine in violation of KSA 21-5706, AC1, possession of methamphetamine, a level 5 drug felony. And that is a reading of the charge in its entirety.
Okay. I didn't have methamphetamine, so I don't know. I guess then that's something I need to talk to my lawyer about. That's what I don't understand.
Yes, and I would advise you not to get into any discussion at this point in time without the benefit of counsel.
Well, maybe you'd remember if you weren't on methamphetamine.
Mr.
Sure,
Skilling, you do have the right to.
Go ahead. I'm sorry. I was just saying I didn't. You asked if I understood it, and I didn't because of that. So that's all I was saying.
Okay. Mr. Skilling, you do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Are you currently employed?
Yes,
What type of work do you do?
I'm a lubrication technician.
And how many hours do you typically work a week?
40, minimum of 40.
And now you know why Manuel suggested it. Because this gentleman is a lubrication technician.
And what is your hourly rate of compensation?
About 30.
$30 per hour.
Mm-hmm.
Based on that level of full-time employment of at least 40 hours a week at $30 per hour, the court finds you do not qualify for court-appointed counsel. You may retain whomever you wish. You may retain whomever you wish to represent you herein. The court sets your next appearance before Chief Judge Rickey, and that would be on the felony preliminary hearing control docket, Monday, December 1, 2025, 2:30 by Zoom. Monday, December 1, 2025, 2:30 by Zoom before the Chief Judge Rickey. And Mr. Skilling, your counsel has been denied based on your level of compensation and your full-time employment. Your bond has been, well, just a moment. I don't believe we've taken up the issue of bond, have we, Mr. Regier?
Your Honor, the state's information is that previously this matter came before the court on January 22nd of this year. However, this is a case where it would appear that the information was not filed until subsequently in September of this year. The state's information is that Prior to that January 22nd hearing, a professional surety bond in the amount of $5,000 had been executed. The state would be requesting clarification as to whether that is still a valid bond or if the court needs to set another bond under these circumstances.
Okay, I do not show any type of a bond in the paper file. If there is a record before the prosecution of a $5,000 surety bond, the court approves that bond going forward. $5,000 bond is approved going forward, if in fact that is the status. Mr. Skilling, have you already posted a $5,000 surety bond?
Yeah, I believe so.
Then that bond remains in force and effect.
And Your Honor, the state does have one final oral motion on the issue of bond for the court's consideration.
Yes.
Your Honor, in this matter, the state is seeking to add an additional condition of bond that the defendant be subject to pretrial court services monitoring during the pendency of this case. Besides the nature of the charges currently before the court, this is a defendant who the state's information has been convicted in Butler County courts over the last approximately 2 years on 3 separate actions. In January of 2024, in 23 TR 632, in June of 2024, in 23 TR 2330, and in September of this year, so approximately 2 months prior, in 25 TR 1327. In that matter, there does appear to, it is the state's information that the court did order that the defendant be granted reporting probation for a period of 1 year. So the state respectfully submits that pretrial court services monitoring in the current case is appropriate.
All right, that'll be the order of the court. And Mr. Skilling, you do need to check in weekly with court services. Mr. Skilling, do you have a pencil and piece of paper?
Yeah, do I use the same one I'm with right now?
Yes,
Okay, or the same lady that I'm dealing with right now?
yes. Who is
Okay.
that? What's her name?
Hang on 1 second. I can get that for you. Marcy Torres?
Tarones?
Yeah.
The court does order you to report as directed by Ms. Tarones. Anything further, Mr. Regier?
No, Your Honor.
And Mr. Skilling, any questions?
No. I only have till the 1st to find my own lawyer? Or,
Well, your next date, and that's before Chief Judge Rickey, and that is on December 1st at 2:30.
okay.
Yes, you need to get on top of that.
Yeah, I just was expected to get a court appointed because that's what's happened in the past. I'm guessing, is it different because of the cases and stuff than what it was in the past?
No, based on 40 hours of work
Right.
per week, based on $30 per hour earnings, you do not qualify for a free court-appointed attorney.
What is with people tonight on these dockets? We've got the one guy saying, well, in Wichita, it was never a felony to have meth, and they caught me several times. And now we've got this guy, well, I've always gotten a free lawyer. Oh boy.
Okay.
You need to retain an attorney to represent yourself.
Okay, and I'm just asking because in the past, the same situation, same earnings and everything, I've been granted one. So that's all I'm asking. So, and if that's your choice, that I'm just asking because I'm only income.
Well, it's basically not my choice. There's certain guidelines, and I can tell you that you're about double income past the high end of the guidelines. if it's State of Kansas Board of Indigent Defense Services,
Okay.
and I'm not trying to be difficult with you.
No, absolutely.
I'm just
I don't
finding,
either.
I don't know why you were appointed counsel previously if you're making $30 an hour and working full time.
I don't know. I filled out one of those, the paperwork, where you fill out your income and all your expenses and family household and all that stuff. But that's fine if that's it. I'm just curious because now I have to find the money for that. So, okay.
Well, I don't really have any other answer.
Okay.
Just the
That's
fact
fine.
that how many dependents do you have? Do you have 12 or 14?
No, I have 5 of us and I'm the only income. So but
The court is going to maintain, I think even with 5 dependents, I think at 30,000 or $30 per hour full-time employment, I don't think you even come close to getting a free attorney.
sure, and I understand that. The only reason I'm asking is because it's happened in the past, and that's so I
Sure.
thought it would here. So yeah, I apologize for being difficult or asking questions. Yeah, that was okay.
This is the time for you to ask questions. It's perfectly all right.
Okay. Well, thank you for that. That's my only thing is,
It's a good thing he's a lube tech because he's beating a dead horse.
that was my only thing because I got to figure out how to do that, come up with the money for retainer and all that stuff. But anyway.
Okay. Court is in recess. You're free to go.
Thank you.
Have a good day.
You too.
Requested first case on the warrant to show cause docket.
No preference from the state, Your Honor.
Thank you.
Your Honor, Mr. Wilkinson, I understand is at the jail. That's perhaps a good place to start.
Okay.
Brian. Oh, it's all in one. Where
Case is entitled State of Kansas versus Brian Wilkinson, 23 CR 3402. State by Mr. Regier, defendant Mr. Wilkinson in person, and by Mr. Watts. Matter does regularly come back before the court this date. Also appearing at this time is Christy Ashtonfelter with Community Corrections. And announcements to the court, Mr. Watts.
Well, Your Honor, I spoke with Mr. Sweeney earlier today, whose case this is kind of in the beginning. It's my understanding that Mr. Wilkinson is in custody on a City of El Dorado commit. He came in April of 2020, in April of this year, and the show cause was filed September 18. I also understand that, and again, correct me if I'm wrong, that he is in custody because he was ordered to do and agreed to do a 2-day commit, and then ultimately did not appear for that 2-day commit, and has been in custody since. So my understanding, speaking with Mr. Sweeney, was the state was going to basically call it time served and put him back on probation. Mr. Regier, are you familiar with something different?
No, Your Honor. Your Honor, the state has no objection to proceeding in that fashion.
That'll be the order of the court. Anything further, Mr. Regier?
Your Honor, is the court reinstating probation for a certain period of time?
And recommendations from Ms. Tronis?
Your Honor, I'm the probation officer on this case, and I have nothing to add.
And do you wish to have the probation extended for a period of 1 year from today? Or do you want to keep?
Yes, Your Honor, I think that'd be appropriate.
That would be the order of the court. Probation is extended with community corrections 1 year from today. Any objection, Mr. Watts?
No, Your Honor. Perhaps we ought to hear from Mr. Wilkinson's his position, he has any objection.
And Your Honor, the state would also be requesting a ruling as to whether or not the defendant is waiving his right to evidentiary hearing and has successfully stipulated to the violations.
And Mr. Wilkinson, Mr. Watts has advised the court, you do wish to admit to being in violation of the terms and conditions of your probation. Is that correct?
I haven't been able to speak to Mr. Watts about this matter at all, on this situation. So I have not had any counsel in this matter at all. But my belief is that the last time I was in Mrs. Ashenfelter's office was the day before, was the day that I got put on this 1-year commit by municipal court. I did not fail to show up to any probation, and I believe this is malicious prosecution, the entire case, because I've been in custody the whole time and had no opportunity to go to Mrs. Ashenfelter's office. You know, I was there the day that I was put in jail, and I've been in jail ever since the last, since about 3 hours after I was in her office.
Thank you, Mr.
Judge,
Wilkinson.
And Your
Excuse
Honor, I'm sorry, Your Honor.
I believe Mr. Watts, Mr. Wilkinson wishes to talk to you more fully about the status of the case. Mr. Wilkinson, I may have been moving too fast in regards to the proceedings. My apologies. I'm not trying to have you proceed in any manner that you do not agree to. So subsequently, I'm going to move you in what's called a breakout room with Mr. Watts, and you can more fully discuss the status of your case.
Heaven forbid you do anything that a defendant doesn't want you to do around here.
Thank you, Your Honor.
Yes, sir. And Mr. Watts, are you ready to proceed with Mr. Wilkinson?
Yes, Your Honor.
And the court goes back on the Zoom record. Once again, State of Kansas versus Brian J. Wilkinson. Case number is 2023 CR 302. And Mr. Watts represents Mr. Wilkinson. Mr. Aguirre is representing the state. And once again, announcements to the court, Mr. Watts.
Thank you, Your Honor. Your Honor, I will simply note, my client is incarcerated, as we mentioned earlier, on a City of El Dorado case. He entered that admission, according to the jail's record, on the 21st. My client tells me that's actually the 13th of April. That conviction dated to 2023 prior to this case. So that conviction cannot be the basis of this revocation. My client would not stipulate that he had failed to report. In fact, his probation officer knew exactly where he was. And obviously, while he is in custody on a City of El Dorado commit, is absolutely unable to report. And I will note that the current warrant to show cause wasn't filed until September 18, some 5 months after he was in custody in the city case. So while we acknowledge that the time he has served since September 18 should be counted in this case, and I think we're open to whether or not he should be extended. I will tell you, my client doesn't believe he should be extended at all on this probation. I understand why he might be, but I don't believe it's appropriate to find that he has violated his probation in this case. He has been in custody on an unrelated matter that dates to prior to his being placed on probation.
Thank you, Mr. Watts. Mr. Watts, just out of curiosity, he's on a commit from the City of El Dorado for how many months?
For 12 months, Your Honor.
Wow. You know, there's a big difference in how Watts advocates for a client when he actually speaks to them.
He's in jail, in the county jail, on a City of El Dorado case for 12 months.
That's my understanding. Yes, sir.
Oh my goodness.
On April The jail says entered on April 21. My client says on April 13. But yes, since April of this year.
All right, so he's going to be in the Butler County Jail on a City of El Dorado commit for a period of a year,
That's my understanding, Your Honor.
and he will be eligible for release in April of 2026.
That is my understanding, Your Honor. Yes, sir.
Okay, and Ms. Ashenfelter, what is the out date for Mr. Wilkinson's time on community corrections? What's his out date on that?
Your Honor, his expiration date for probation is December 4th, 2025. I do think that there's been some miscommunication or something along that lines. My warrant didn't allege any type of new conviction. That's not what it was for. It was just to get the defendant back in front of Your Honor to extend him on the case. I'm still willing to work with him on this, even after he gets done with his city revocation. Other than that, I don't have anything else to add.
Thank you, Ms. Ashenfelter. Mr. Wilkinson, you present a very unusual case. I don't believe I've ever had a City of El Dorado or any city in the county commit for a year in the Butler County Jail, but apparently that's what Mr. Watts is advising the court. So subsequently, the court is not finding you in violation of the terms and conditions of your probation. The court does set and does believe it is appropriate due to your current incarceration that your probation period of time with community corrections would be extended for 1 year from today, from today, but the court is not finding any violation of the terms and conditions of your probation. Do you have any question about that?
Your Honor, because of the maliciousness of the police officers in this town, as soon as I get out of this jail, I want to leave this state. And if my probation is extended, I will not be able to leave this state, and I will still be subject to malicious police officers attacking me due to the fact that because of my prior conviction and my time at Lansing from 1999 to 2001 of abuse of a child, the police officers here think that I'll never have done enough time for that, even though I completed my parole without any violations and am not a threat to any public persons or myself. They want to keep throwing me in jail because of something that happened in the last millennium.
Well, probably the best solution for the good citizens of the state of Kansas is for you to take yourself to some other jurisdiction. I'm not disputing that with you.
That's the nicest stay out of Fulton County I've ever heard.
But I believe it is appropriate that once you've served your time in El Dorado from the El Dorado Municipal Court case, that you then are still, I believe it is appropriate to extend your probation for a year from today. When you get out of Butler County Jail for the City of El Dorado crime, you need to check with community corrections to see about whether that can be transferred to the new state that you're proposing to relocate yourself to. So I'm going to go ahead and keep that in force and effect. Community corrections probation is extended 1 year from today. Upon your release from the Butler County Jail for the City of El Dorado crime, you need to then check with community corrections, Ms. Ashenfelter, or appropriate officer at that office, and have your community corrections transferred to whatever location you are relocating to.
Okay, is Miss Ashenfelter on this? Can she hear me right now?
She is, yes.
Miss
She can,
Ashenfelter? Am I eligible for day good time while I'm in custody so that my 1 year will be only 6 months?
well, I think that's a better question for the court. I'm not giving you day-to-day credit for your Butler County case number 2023-302. I'm not giving you day-to-day credit for that. You're extended on your community corrections probation for 1 year from today. And I've tried to give you a little bit of guidance in regards to when you have served the entire amount of your city of El Dorado time, that you then advise Ms. Ashenfelter of where you are relocating to, so that you may have your community corrections transferred. It may not be able to be transferred. It may have to stay right here, and you may have to remain until 1 year from today. But all that is an unknown at this time.
And Your Honor, I would note, I think it's appropriate for Mr. Wilkinson to get credit against his underlying jail sentence from the time this warrant to show cause is filed, which would be September 18, to at the very least today's date, and potentially until he's released. I understand the court's not making a finding, but the result is he was booked in, my understanding, on this warrant to show cause, as well as his city case. And I think he's entitled to, at the very least, credit for from that date to, at the very least, today's date.
Well, there is maybe some new case law in regards to credit for time served, and I'll be happy to take that up upon proper motion, Mr. Watts. At this point in time, I'm going to maintain the order in force and effect that I previously have entered, but you may very well be correct. The Kansas Court of Appeals may very well have changed the credit for time served in regards to other cases that are being served along with this case. So I'm not denying that possibility at all.
Judge, I'm not alleging the other cases. I'm alleging only the time he served since this warrant to show cause was filed. And he was booked in on this warrant to show cause as well as his city case.
It's the court's understanding he was not booked in on this case. He was already serving the city of El Dorado case. I could be wrong. I don't know, but that's what's been placed before the court. Is that not correct, that he was already in jail when the warrant to show cause was served upon him?
He was, Your Honor, but he is also recorded in the jail on that as well as the other matter. And I think they are presumed to be running concurrent. I don't think there's any order that they run consecutive to each other that I'm aware of. So I think he is entitled to the time since he was being held on this matter as well as the city court matter, again, from September 18 to at least today's date.
Court gives credit for time served from September 18 to today's date, as the court finds that these sentences were not ordered to run consecutive. Therefore, it's presumed they are run concurrently, and that will be the order of the court.
Thank you, sir.
Mr. Wilkinson, anything further to come before the court?
I believe that you have tried to treat me as fairly as you're able to. And I thank you for this, Your Honor. And I believe that settles whatever matters we're here for today.
Anything further, Mr. Regier?
Not from the state, Your Honor.
And anything further, Ms. Ashenfelter?
No, Your Honor. Thank you.
Anything further, Mr. Watts?
No, Your Honor, thank you.
There being nothing further to come before the court is in recess.
I honestly was expecting a much more Karen-esque response from him. When he started with, I believe, I was like, oh, here we go. And then he was actually decent about it.
Good luck to you, Mr. Wilkinson.
Thank you, Mr. Trump.
Trump.
And I probably should speak with him before we get started. And Joe may have something waiting as well while I'm doing that.
Well, both of mine are again in custody, and I need to speak to them briefly. But Mr. Parker, called me finally, and he's supposed to be getting on, but he's not yet. So I don't know what's going on there. So I'm kind of at a standstill.
If I could do a breakout with Mr. Taylor, Your Honor.
Okay, court asks Belen if please do a breakout room with Mr. Taylor and Mr. Watts. Court will take a 5-minute recess. And announcements to the court, Mr. Watts.
Your Honor, I've discussed the matter. Oh, yes, there we go. I am off. Discuss the matter with my client. It is my understanding he would stipulate to the third allegation in the warrant to show cause. He failed to report to his ISO on May 28. Was rescheduled to May 30 and missed that May 30 meeting as well. He would decline to stipulate to engaging in any sort of assaultive behavior or being under the influence of alcohol or failing to report those law enforcement contacts.
Thank you, Mr. Watts. And once again, this is Mr. Taylor.
This is Mr. Yes, sir, Mr. Taylor.
Mr. Taylor, Mr. Watts has advised that you do wish to admit to being in violation of the terms and conditions of your probation, as Mr. Watts has set forth on the record.
Yes.
Pardon me?
Yes, Your Honor.
You understand by making this admission, the court could very well revoke your probation and order you to serve the balance of your sentence previously imposed. Do you understand that?
Yes, Your Honor.
Have you had adequate and sufficient opportunity to consult with Mr. Watts prior to making your admission here today?
Yes, Your Honor.
Mr. Taylor, the court does find that you are knowingly and voluntarily admitting to the probation violation, and the court does accept the same. Recommendations for disposition, Mr. Regier?
One moment, Your Honor. Your Honor, the state is prepared to defer to the court as to determine an appropriate sanction up to including full revocation.
And at this point in time, Mr. Watts, recommendations?
Your Honor, Mr. Taylor has been in custody now on this matter. He's arrested October 2nd of 2025. So he's been in custody approximately 6 weeks at this point. I understand he has not done a dip or dunk. If the court thinks it's appropriate, and I certainly understand why the court would believe so, to pass that step and assign a dip or a dip in this matter. He has been in custody for 6 weeks. We'd ask that time be served, plus any additional dip sanction the court believes is appropriate, and placing back on probation on this matter. He can successfully complete this probation, Your Honor, I'm confident.
Thank you, Mr. Watts. And recommendations from Community Corrections, Mr. Ketley?
Your Honor, I would recommend his probation be revoked to serve his time. He's at A box, he's presumptive prison, and he failed to report. There's other stuff going on also.
Thank you, Mr. Ketley.
And Your Honor?
Mr. Regier,
One final point before the court proceeds to its ruling.
please proceed.
Your Honor, this is a case where it would appear that a journal entry of felony conviction and sentencing was filed with the court in May 2025. Page 3 or 4 of the same does appear to indicate that the court did grant a downward dispositional departure. So it would appear that the intermediate sanctions as typically found as required by statute does not apply in this case based off the state's understanding.
All right, you're saying that the intermediate sanctions do not apply, such as dips and dunks?
Based off of the prior disposition, departure being granted, Your Honor.
So the prior departure was granted, therefore the court does not need to order dips or dunks. Is that correct?
That would be the state's understanding of the applicable laws, Your Honor.
Thank you. Well, there's quite a diverse recommendation that's coming before the court. Community Corrections, who has been overseeing the probation of Mr. Taylor, is recommending, Mr. Taylor, that you be revoked from your probation and ordered to serve the balance of your sentence. I am finding that the only violation that you are admitting to is that you failed to report to your ISO on May 28 and were rescheduled to May 30, 2025, and you failed to report. So subsequently, you have not made an admission to number one, that you engaged in assaultive behavior on May 9, 2025, as alleged in Wichita Police Department incident report number 25C079538, and you failed to notify your ISO of your law enforcement contact within 24 hours. Also, you have not admitted to your May 24, 2025 incident that you were under the influence of alcohol as alleged in Wichita Police Department incident report number 25C093443, and that you failed to notify the intensive supervision officer of your law enforcement contact within 24 hours. So based on the admission that you have made here today, the court does retain you on your community corrections probation.
Since when do we just take the defendant's word for it? There's that mighty fine officer sitting right there. I mean, he may not admit to the other violations, but I'm sure we could have some input on them.
The court does order a 2-day dip, so you will be released. You'll be eligible for release on Sunday at 3:30 p.m. You'll be eligible for 3:30 p.m. And the court does order that you report as directed by Mr. Ketley. Even though Community Corrections doesn't want you back, they want you in prison. I am ordering you back on Community Corrections based on the admission that you have made today. And subsequently, what date, Mr. Ketley, would you request Mr. Taylor report to Community Corrections?
I will be back in Wichita next Tuesday on the 18th. He can come see me there at 9:05 at 2:30.
And Mr. Taylor, are you familiar where to meet and the place and the time and the date?
Yeah, you said November 18th?
Yes, next Tuesday. Yes.
At 2:30.
Next Tuesday at 2:30. And the place where you're going to be meeting Mr. Taylor?
Yeah, it's the 905 building, correct?
Yes.
Anything further to come before the court, Mr. Regier?
Your Honor, for the purposes of the journal entry, the state would be requesting as to whether or not credit for time served is to be granted, if indeed that's not to be applied to the 2-day dip. And the court would also request the court make a ruling as to whether or not probation is to be extended in this case, and if so, for what period of time.
The court does order the extension of Community Corrections probation for Mr. Taylor 1 year from today. The court does order credit for time served for the period of time that Mr. Watts set forth on the record. I believe that's from September 18.
No, so that was the previous case. The warrant to show cause file indicates he was arrested on October 2nd.
So credit for time served is ordered by the court October 2nd. through today, November 14. And what other request is made?
Nothing further from the state, Your Honor.
Thank you, Mr. Regier. Anything further from the defense, Mr. Watts?
No, sir, thank you.
Anything further from community corrections, Mr. Ketley?
No, Your Honor.
And do you have any questions, Mr. Taylor?
No, Your Honor.
There being nothing further, court is in recess. Have a good day.
Thank you.
You're free to go.
Real fast, Your Honor, if the Wichita police officer, Mr. Zimmerman, was only here on the last case, could he be excused?
Yes. He's excused. Mr. Zimmerman is excused from the proceedings, or Officer Zimmerman.
Thank you,
You're
Your
fr-
Honor.
You're free to go. And Joe, you want to take up your case?
Well, Judge, that depends on if Mr. Parker is present at court security. The other two are both in custody.
Mr. Parker is not at the courthouse.
Oh, no. Okay.
Okay, we'll take up Mr. Parker. State of Kansas versus Logan Dale Parker, 24 CR 512, state by Mr. Regier. Defendant fails to appear but by Mr. Favre. Matter does regularly come back before the court on the warrant to show cause docket. And once again, Mr. Parker has failed to appear. And subsequently, the court orders bond forfeiture bench warrant. And court finds that Mr. Parker was on a $2,500 cash or surety bond. The court orders a $5,000 cash or surety bond, a new bond in the amount of $5,000 cash or surety. That's simply doubling the current bond as I show. Anything further, Mr. Regier
Not from the state, Your Honor.
and Mr. Favre?
Nothing, Your Honor, no.
Court is in recess.
And Your Honor, that clears the jail, so I guess Joe can meet his clients and I can do a breakout with Mr. Branscombe and we can get all these matters resolved.
Judge, maybe so we can keep things going, we can take up Mr. Parker now while Jim is meeting with Mr. Branscombe. And then when he comes back with Mr. Branscombe, I can go back into the jail. That way we can just keep the docket flowing still.
Okay.
Case is entitled State of Kansas versus Logan Parker, 24 CR 512, state by Mr. Regier, defendant in person and by Mr. Favre. Also appearing at this time, Court Service Officer Sarah Wheeler. Matter comes back regularly before the court. And announcements to the court, Mr. Favre.
But Judge, first we'd like to apologize for Mr. Parker's tardiness. He apparently had made a mistake on his calendar and had it down for Monday. But I was able to reach his parents who got a message to him and he was able to get on. So we're sorry for that. We'd asked the court to withdraw the previous order for a warrant.
So ordered. Warrant
Thank you.
withdrawn.
In regards to how to handle this matter, at this time, Mr. Parker has been advised of his right to an evidentiary hearing and the allegations made in the warrant to show cause. He's going to stipulate to the allegations in that warrant to show cause at this time.
Thank you, Mr. Favre. Mr. Parker, Mr. Favre has advised the court you do wish to admit to being in violation of the terms and conditions of your probation. Is that correct?
Yes, Your Honor.
You understand by making this admission, the court could very well revoke your probation and order you to serve the balance of your sentence previously ordered.
I do, Your Honor.
Have you had adequate?
Looking for the best.
Pardon me?
I'm sorry, Your Honor.
I couldn't hear you. What did you say?
I said I'm just wishing for the best.
You are wishing for the best. Is that correct?
Yes, Your Honor, because I'm trying to get my act up better and together.
Do you know of any reason why the court should not proceed at this time?
No, Your Honor.
Mr. Parker, the court does find that you're knowingly and voluntarily admitting to the probation violation or violations, and the court does accept the same.
Oh, he didn't learn from Watts's client, where if you only admit to one violation, they can't find you for the other ones.
Recommendations for disposition from the state, Mr. Regier.
Your Honor, I have no personal knowledge as to whether there have been any communications between my office and counsel for the defense. The state's information is that the information originally filed in this case was filed by my colleague, Mr. Sweeney. Although the journal entry more recently does appear to have been signed by my colleague, Ms. Norris. In either event, the state does consider the violations of as alleged and stipulated to in the request for revocation to be quite significant, both in terms of their number and severity. State's recommendation is that the or proceed to outright revocation. If the court does determine that a modification of the original sentence in this case is appropriate, well, I'll leave it at that, Your Honor. It would appear that previously the court had ordered 6 months consecutive sentences with respect to counts 1 and 2.
Thank you, Mr. Regier. And recommendations from defense, Mr. Favre.
Your Honor, I've spoken to Mr. Parker. Mr. Regier accurately states that we have a 12-month total underlying sentence with those 2 6-month sentences running back to back. Mr. Parker would at this time request the court to impose a dip sanction and return him to probation. We'll note for the court, this is the first time he has been in violation of his probation. It is a misdemeanor case, and he was originally given a misdemeanor case because of his lack of criminal history in his youth. So that's why he was given a misdemeanor offer to begin with. He tells me that he did have some struggles reporting, but he did report despite those 2 times fairly regularly. He also is very interested in drug treatment, but he's just been homeless. It's been hard for him to pay for it. He doesn't have the resources, so he needs some financial assistance to help him get into treatment. Unfortunately, not qualifying for Senate bill at this time because of the misdemeanor is something that is kind of it's harming him being able to get the treatment he needs. So we asked the court to consider giving him a dip, reinstating him, and he will continue to report to probation, and hopefully they can help him find some resources to be able to get the drug treatment that he needs at this time. Oh, and he also is just barely recently employed. It is a fast food job, but he did obtain employment recently. So.
Thank you, Mr. Favre. Recommendations from court services, Ms. Wheeler.
Yes, Your Honor. I will let the court know that a part of the revocation was that Mr. Parker picked up a new domestic violence case. He has been convicted on that case and sentenced to 12 months court services probation. So I have him on the new offense. That probation began September 29 of 25. He shortly thereafter had gotten picked up on this warrant. I directed him to call me with his first appearance date. He never did that. I'm really hesitant with this probation. I still have him on the other case, so I'm not saying that I wouldn't take him back on probation, but there's just been no positive momentum. So I am concerned about the success of Mr. Parker's probations. At this point, we have more than one. He's been ordered to do the batterer intervention assessment and follow recommendations in both of the cases, has never gotten that completed. And his probation in this case began back in January of 2025. So we're pushing a year with effectively nothing done. So I am concerned As far as the recommendations go, I really don't know, Your Honor. I don't know.
Thank you, Ms. Wheeler. Mr. Parker, the court at this time has had the opportunity to listen to the recommendations of the state, your defense counsel, and court services. Subsequently, the court finds you're not amenable to probation herein. Court subsequently does revoke your probation and orders you to serve the balance of the sentence previously imposed, a total of 12 months. Subsequently, the court does order that you surrender yourself to the Butler County jail 5 o'clock this evening. 5 o'clock this evening. Any other matters to come before the court, Mr. Regier?
Not from the state, Your Honor.
Mr. Favre?
Judge, we would move to have the court modify that. These are 2 6-month sentences. We'd ask the court to modify them to concurrent with one another. That would make his underlying only 6 months. And
Shouldn't have admitted to it. You gotta take the master class from Watts.
in support of that, we would note that, the lack of progress is kind of a two-edged sword. As we noted previously, in this 10-month period he was on probation, he did fail to report, but he never dropped totally off the radar. He only failed to report twice. He's just had a hard time. He's young. He was unemployed. He came in with almost no history. So I think 6 months is a big enough sting. Plus, it hinders his other probation case, which, as Ms. Wheeler noted, he was just placed on. So this ruling will hinder that case as well. We think 6 months is a big enough sting to make a point. We'd ask the court to consider modifying the sentence to being concurrent.
Thank you, Mr. Favre. Response in regards to the motion for durational departure from 12 months to 6 months from the state's perspective, Mr. Regier?
Your Honor, it would appear that the court has already pronounced its ruling from the bench. The state is not aware of any additional information which would legally suggest a departure from the court's earlier pronouncement of its ruling to be appropriate. Additionally, I would tell the court that in the 25 CR 359 case, it would appear that the defendant was convicted of amended count 1, domestic battery. That would appear to be the same charge in count 1 in the 2024 current case. The state respectfully submits that the court should stand by its earlier ruling, and the state does likewise stand by its earlier recommendations.
Thank you, Mr. Regier. Further recommendations from court services, Ms. Wheeler?
The only thing that I would say is that the additional count in this current case is the possession of paraphernalia. It's not uncommon to see a lesser amount on that one. However, the agreement at the time that he pled was for 6 months. So I'm okay with what Your Honor decides.
Thank you, Ms. Wheeler. The court does grant the durational departure motion of the defense. The court does order that Mr. Parker serve a total of 6 months in the county jail in regards to sentence in 24 CR 512. The same is modified from 2 consecutive 6-month sentences to 1 total 6-month sentence as motioned and ordered by the court here today. Anything further, Mr. Regier?
Not from the state, Your Honor.
Mr. Favre?
Not at this time, Your Honor.
Ms. Wheeler?
No, Your Honor.
And Mr. Parker, I do order you to surrender yourself to the Butler County Jail 5 o'clock today. Court's in recess.
Yes,
All right, court goes on the Zoom record. Case is entitled State of Kansas versus Brandon Branscombe, 23 CR 482. State of Kansas appears by Assistant Butler County Attorney Jared Regier. The defendant, Mr. Branscombe, appears in person and by court-appointed counsel Jim Watts. This matter does regularly come back before the court this day on the warrant to show cause docket by Zoom. Also appearing at this time, Court Service Officer Ryan Smith. Announcements to the court, Mr. Watts.
Your Honor, as to the allegations of the warrant to show cause, my client would acknowledge that he failed to report as directed and that he missed appointments on March 26 and April 17. He would acknowledge that he has not paid on this case, court costs and fines. He's now working, however, believes he can get that done very quickly. And finally, he would acknowledge that he had a violation of the law. It's my understanding that the domestic violence battery case that is alleged has now been completed and is final. He would stipulate that he in fact did violate the law in that respect. Would waive hearing on those matters.
Thank you, Mr. Watts. Mr. Branscombe, Mr. Watts has advised the court you do wish to admit to being in violation of the terms and conditions of your probation as set forth on the record by Mr. Watts.
Yes, sir. I understand the allegations, Your Honor.
And by making this admission, the court could very well revoke your probation and order you to serve the balance of your sentence. Do you understand that?
Yes, Your Honor, I do.
Have you had adequate and sufficient opportunity to consult with Mr. Watts prior to making your admission here today?
Yes, Your Honor.
Mr. Branscombe, the court does find that you are knowingly and voluntarily admitting to the probation violations, and the court does accept the same. Recommendations for disposition, Mr. Regier.
Your Honor, pursuant to the request for revocation in this matter, it would appear that at the time that such request was submitted, it was recommended by the court services officer that the court impose a 30-day jail sanction, that the defendant reinstate probation, extended probation for a period of 1 year. State would have no objection to the court making those the orders of the court. It would also appear that the court services officer further recommended that the defendant be ordered to complete a new drug and alcohol evaluation. Although it would appear that while it would not appear that any drug or alcohol violations were stipulated to, it would appear that this is a defendant who had previously been ordered to serve a 2-day dip for such a violation.
Thank you, Mr. Regier. Recommendations, Mr. Watts.
Your Honor, my client understands the sanction that's asked for, and he understands there's a necessity for that sanction. He would tell the court that he has already begun the batter's intervention and anger management classes and marriage counseling. That's part of the domestic violence case. He's making progress on that front. The most important thing that Mr. Branscombe is concerned about, and completely understandable, is his job. He has been employed. He tells me he's reported that employment to Mr. Smith and has provided documentation of that employment. A 30-day stint in the Butler County Jail as a solid 30-day run will probably cost him that employment. And it's employment that Mr. Branscombe reports he's making progress on. He's believes he's going to be getting a promotion soon. Will be able to make more money and more responsibilities and move up in that employment. We all know how important employment and steady employment and good employment is to being successful on probation. So we would ask that whatever sanction the court does is fashioned in a way where Mr. Branscombe can continue that employment.
Well, we all know. The defendants, on the other hand, it's questionable whether or not they know.
And continue to proceed in that employment. There's also apparently a child in needed care case that he wants to make sure that he is present for. He's very important for him, for obvious reasons, to participate in that case. And that's very difficult to do from the county jail. So, Judge, my client would ask that he be able to serve any sanction the court orders on a weekend basis so he can keep his employment and appear for court as ordered.
Thank you, Mr. Watts. And recommendations, Mr. Smith?
Yes, Your Honor. If I could give the court some additional context about the case. This is a case that originally started off as a warrant or as a felony in front of Your Honor. And the court had ordered me to supervise him on bond supervision. So I have been supervising Mr. Branscombe essentially since October the 6th of 2023 in this case. He had a very rocky start during the bond supervision phases of the case. He had a very rocky start to probation. Since the filing of this warrant, it seems to have motivated Mr. Branscombe to get his act in order. He has provided me proof that he is employed. It does appear to be gainful employment and steady employment. He has provided me proof that he is attending the batter's intervention program and does seem to be on the right track now. His main area of concern for me is his drug use. So I would ask the court to fashion a sanction for him to be able to keep his job, but also work on all of the things that he needs to work on, such as his batter's intervention program and a drug and alcohol treatment class.
Thank you, Mr. Smith, for your insight. And Mr. Branscombe, the court does adopt the recommendation as set forth on the record by the most familiar party that's been working with you for approximately 2 years, Mr. Smith. The court finds that you're requesting that you serve on the weekends, and the court does impose 30 days in the county jail, that to be done on the weekend. The court subsequently adopts the other recommendations as set forth on the record here today. What time to check in and the time to check out on the weekends, Mr. Branscombe?
My scheduled days off at work are Wednesdays and Thursdays. I work third shift, so I get off at 7 in the morning. So whatever, and it's in Lawrence, Kansas. I don't know if there's a way that I would be able to serve those in the Lawrence County Jail. I believe when I talked to them about this previously, that they told me I would most likely have to pay the jail to be housed to be able to do that.
Yes, you would need to pay the Douglas County Jail to be housed at the Douglas County Jail. So, what are you asking for? You're asking for Wednesday and Thursday, is that correct?
Yes, Your Honor. Those are my scheduled days off. So
that'll be the order of the court. What time are you to be reporting to the Butler County Jail, and then your release time?
Will I be able to do that at the Lawrence County Jail? How do I go about doing it? I'm sorry. I'm confused. If I was to pay the Douglas County Jail to be housed, I can't do them there.
Well, Mr. Branscombe, and I've had a few clients do that. It's arrangements you really need to make in advance. They're going to charge you for that time, probably in the neighborhood of $75 to $125 a day. I don't know what the current going rate is for days in jail, but it's not cheap. You're looking again, $75 to $125 a day. I don't know if the Douglas County Jail would even accept you.
Okay, all right. Well, I'll just plan on doing it. Trying to figure out a ride every week down there, and I'll make it happen. Time to report into jail. If I get off at 7 in the morning, so say noon 1 o'clock on Wednesday.
Noon on Wednesday, and released Friday at noon. Is that correct?
Yes, Your Honor.
That'll be the order of the court for 15 periods of time, 15 two-day periods of time.
Thank you, Your Honor.
What date would that commence? What date would that commence? What date would that commence?
Can you start that this Wednesday?
If need be, yes. If I can get the following Wednesday, then that would be more helpful for me to try to arrange everything. But if not, I'll be there whatever day I'm told to be.
Proposed starting date, Mr. Watts.
Your Honor might suggest to begin, well, next week. Well, let's see here. Wednesday would be the 19th. The following week would be Wednesday and Thursday is Thanksgiving week. This is a little bit of a break, but given that Thanksgiving is Wednesday and Thursday, perhaps the week following Thanksgiving, which would be Wednesday, December 3.
They can be in jail on Thanksgiving. The jail even serves turkey and cranberry sauce. They do. I mean, it's not great, but they do.
Wednesday, December 3rd is your day, first day to report in. Wednesday, December 3rd at 12 noon to report in to the Butler County Jail.
Yes, Your Honor.
Okay.
One more thing, if I may. As far as probation, do I need to keep calling and reporting to Ryan, or do I need to start reporting
Yes.
to Douglas County, or how does this work?
Your Honor, I
You're
would,
to
I'm sorry.
No, you're to be reporting to Butler County Court Services. Ryan Smith is your court service officer, also known as your probation officer.
Yes, Your Honor.
And Your Honor, if I may,
Yes,
if it works for you to report in Lawrence, that might be possible, but that has to be approved and done through Ryan. He may believe that's appropriate, he may not, but Ryan will need to approve that, and you have to go through him to do that.
Yes, sir.
any further clarifications of the order of the court, Mr. Regier?
3 points, Your Honor. Is the court ordering that these Wednesday and Thursday sanctions be served on consecutive weeks?
Yes,
Is the court giving the defendant any credit towards the 30-day sanction?
I know, frankly, Judge, I don't know the answer to that. Obviously, there would have been a warrant show cause, an arrest. It shows on October 9 on the warrant show cause. I don't know when he bonded out, so I don't know how much time would already apply.
It was the next day that I bonded out. So I was there barely a little over 24 hours.
Okay.
court orders 1 day of jail time credit
And Your
toward the 30 days.
Thank you, Your Honor. And the state would lastly request clarification as to whether the court is ordering any extension of probation in this matter, if these are the orders of the court.
And recommendation for extension or not, Mr. Smith?
Yes, Your Honor. To make it easier for myself to calculate it, could we extend the probation for 1 year starting on September the 22nd, 2025, as that is the date that he was placed on probation in the other case that I'm supervising him for?
The court does order extension of probation to September 22nd, 2026 on Butler County case number 23 CR 482.
Thank you, Your Honor.
Thank you, Mr. Smith.
Yes, Your Honor. And then I was also asking that he obtain a new drug and alcohol assessment and follow those recommendations if the court was going to make that order.
That is the order of the court.
Thank you, Your Honor.
Thank you.
Any other matters?
From the state, Your
No,
Honor.
Your Honor. Thank you, sir.
Mr. Smith?
Mr. Branscombe, please call me as soon as the hearing is over.
Yes, sir, I will.
Thank you. Thank you, Your Honor.
Do you want to go into a breakout room with Mr. Branscombe?
That's not necessary, Your Honor. Thank you, though.
Okay. Go ahead and call Mr. Smith immediately after the hearing, Mr. Branscombe.
Yes, Your Honor, I will.
Mr. Branscombe, this is an opportunity you're given to successfully complete your probation in this case, and apparently there's another case outstanding. The court has been, in my opinion, very fair, and lenient with you in regards to this matter. Now it's up to you to successfully complete your probation conditions. Do you have
Yes,
any
Your Honor.
questions?
No, just the gratitude, and I thank you for the opportunity to make myself successful with this.
There being nothing further to come before the court, court is in recess. Mr. Branscombe, you're free to go. Mr.
Thank you, Your
Smith,
Honor.
thank you for your appearance. You're free to go also.
And we have one more clip. That first one, the one that the kiddies helped me edit, but I went in and I redid it. Here we go.
And first case is State of Kansas versus Richard Robert Crumrine, 25 CR 289. Stayed by Mr. Regier. Matter comes back before the court this day, and this matter comes back before the court after on 10/21/25 there was a bond forfeiture bench warrant ordered by Judge Satterfield, and the court finds that on the first appearance criminal docket sheet there is currently a no bond hold. Is that what you show, Mr. Regier?
Your Honor, based off the state's information, that would appear to be accurate. Insofar as the court's orders from the October 21st hearing is concerned.
Sir,
Yes.
is there anything, okay, I have 3 cases going on through the county. Is
Yes.
there any way I can, because I got so many dates, I got fine payment dates that I have to pay by, or I get a warrant for my arrest. I have appearances for the city. I'm trying to get everything took care of. Is there any way I can put all my county cases together on, like, having one attorney do all my cases? Because I can't keep track of all these dates and stuff like that. I write it on a calendar, I put it on my phone.
Yeah, I don't know what other jurisdictions.
They're
Are
all
they
Butler County right here. They're all right here in
Okay.
Butler County.
Mr. Crumrine, what I would suggest you do
Yeah.
is to contact Mr. Watts and see if he would be able to make a motion to schedule all the cases before one particular judge or the other. And that way it might lessen the problem of 3 court appearances at 3 different times.
Yeah, I mean, that's why I'm missing court, because I get my dates mixed up of which one I gotta pay for here, and then when I make a payment here or be court here, and I'm horrible with dates. I put it in my phone and I put it on my calendar, and I'm busy working on cars for people all the time, and I get everything confused up on it. That's why I got a warrant here now to the city also because the date I was supposed to make a payment there, I tried to show up for court.
Thank you, Mr. Crumrine. The court sets your case next before Judge Satterfield, and that would be on the preliminary hearing control docket. Wait, apparently preliminary hearing has been waived and arraignment has been scheduled, and apparently you failed to appear on 10/21/25 and handwritten notes.
I got a note thing, the deal that said that it was canceled.
No, just be quiet for just a moment,
Yeah.
Mr. Crumrine. I'm trying to figure out what's going on with your case. Mr. Regier,
The state's information is that previously this matter was scheduled for a pretrial and jury trial, with the pretrial hearing occurring on October 21st. It would appear based off the state's information that the court made a finding that the defendant failed to appear at that setting and entered orders in accordance with that.
And the order that I show handwritten, that I'm familiar with Judge Satterfield's handwriting, it shows bond forfeiture bench warrant. Instead of a no bond hold, it shows in a handwritten notes, 10,000 cash assured.
Yeah.
Your Honor, I have no information insofar as that is concerned. The court's earlier recitation of the court's prior orders would appear accurate based off the document filed with the court on November.
Okay, I'm going to go ahead and since I can view the handwritten notes of Judge Satterfield, I don't see anything else in the paper file. I'm going to order a $10,000 cash or surety bond as opposed to no bond hold. And I'm going to put this back on Judge Satterfield's felony preliminary hearing control docket for Monday, December 8, 2025 at 2:30. Monday, December 8, 2025 at 2:30.
I'll be there. And then you said I need to get a hold of Watts about combining all my cases together?
That's what I would do.
Yeah,
But
I've been trying to figure out if that was possible to do or not, so I wanted to ask.
it may not be possible to do. That's a suggestion.
All right, thank you.
Anything further, Mr. Regier?
Your Honor, as a point of clarification, that December 8th setting, is that for control purposes?
It is. Felony preliminary hearing control docket.
Nothing further from the state, Your Honor.
Court is in recess.
Thank you.
If anyone can help you out, it's Attorney Watts. Oh, that was so much fun. Aw, that's perfectly all right, sweetie. Just ask everybody here. Everybody reaches out to me in different ways. It's not weird at all. But thank you so much. And I asked you like 3 times, which of your beautiful kitties is your profile picture? Because, oh my gosh, that cat is gorgeous. Oh, Mishka's beautiful. I love her eyes. She's got a perfect face. It's like similar to a Maine Coon face, but not as dramatic. I don't know your last name. I can't exactly search manual on Facebook and expect to get you. Aww. The shape of the mouth gives it away. Good night. Me too. Me too. I'm gonna go to bed, you guys. I love you all. Thank you so much for coming and hanging out with me tonight. This was a blast. Be safe, be well, sleep sweet, and much love.